Уважаемые коллеги,
Dear colleagues, we're starting our dissertation council session, and we are dealing with today is the dissertation submitted by Svyatoslav Kovalenko, seeking the degree of candidate of legal sciences and international in law, European law, and the name of the dissertation is Theoretical and Practical Aspects of Evolutionary Interpretation of the European Convention for the Protection of Human Rights and Fundamental Freedoms in the Case Law of the European Court of Human Rights. I would like to now talk about the constitution of this dissertation council. It was established on the first by act of St. Petersburg University, the 1st of October 2019. I, Elena Vladimir Timoshina, Doctor of Legal Sciences, Professor of the Department of Theory of History of State and Law, St. Petersburg State University, chair this session and this academic council. Also, the academic council includes Vera Rusinova, Doctor of Legal Sciences, Professor of the National Research University High School of Economics, Mark Antin, Doctor of Legal Sciences, Professor, Head of Department of European Law of Moscow State Institute of International Relations, University, Gimo, Dmitry Kochinov, Doctor, Professor of Groningen University in the Netherlands, and also we have Vladimir Leonidovich Tolstych, Doctor of Legal Sciences, Associate Professor, Head of Department of International Law of Novosibirsk State University, who is online. And I would like to mention that according to federal law dated 23rd of August 1996, St. Petersburg University was granted the right to issue its degrees independently, and therefore our dissertation council consists of 5 members. Everybody is present, so therefore we have the quorum. We can start our work. I would like to go over the agenda. First, a short presentation of the chairperson of this dissertation council about the documentation that the council has received and whether they comply with the requirements. Then answers to possible questions, 5 minutes, short presentation of the defendant, aspiring this degree for 15 minutes, and I hope that, and then questions to the defendant, strictly according to the presentation, 2 minutes per question, and then answers of the author dissertation, and then all members of the dissertation council will read out their positions, their reviews, and ask questions. 10 minutes per, under 10 minutes per speaker, and then the chairperson will read her review. Then an open discussion, then the defendant will answer questions and the open discussion. And I would like to go over, and then the academic advisor will speak of not more than 30 minutes, and we have 5 minutes for deliberation before a verdict is before the voting procedure takes place. Then open procedure of voting, and then the verdict is taken, and the final statement of the defendant. And now I would like to go to item 1, which is dear colleagues, I would like to present the presentation of the theoretical the work of the Convention of the Protection of Human Rights, Fundamental Freedoms in the practice of the European Court of Human Rights. In my report, I would like to summarize what was stated on the page of my dissertation research. The work consists of an introduction, 3 chapters of the main part, and conclusion. The introduction substantiates the relevance of the topic of the dissertation, analyzes the degree of its relevance, formulates academic relevance, formulates the purpose of objects of study, reveals the object and subject of study. Relevance of the stated research topic is that the doctrine convention as a living instrument which underlines the evolutionary method of interpretation is one of the main distinguishing features of the interpretation that is underscored by the European Court of Human Rights, hereinafter the European Court or the Court. The issues of evolutionary interpretation of the European Court are multifaceted and debatable. Well, there's not much literature that would address this issue. In the first chapter, the concept of genesis of evolutionary interpretation, the law of international treaties, and the practice of the European Court of Human Rights consists of 2 paragraphs. In the first paragraph, analysis was made of the content of evolutionary interpretation, one of the ways of interpreting the provisions of the European Convention for the Protection of Human Rights and the Fundamental Freedoms. The dissertation emphasizes the evolutionary interpretation of the European Convention as a method of interpretation by which judges of the European do not seek to identify the initial subjective intentions of the parties that participate in the drafting and adoption of the text of the European Convention. References to preparatory materials are most often used to set the limits of evolutionary interpretation. The evolutionary interpretation allows us to rethink and expand the content of interpreting concepts, the relatively limited range of civil and political human rights listed in the Convention text, to adapt them to the changing needs of European society. The European Convention as an institutional human rights treaty is distinguished by its ability to modernize due to a number of reasons. Objective, significant changes in public relations of the states of participating in the Convention, and subjective, changes in the contents of the contentions as a result of the action of the subject of evolutionary interpretation, the European Court of Human Rights. The work emphasized that the main function of the evolutionary interpretation of the Convention is to ensure the viability and effectiveness of the text of this international treaty. And the second paragraph, for a more thorough understanding of the essence of the evolutionary interpretation of the content of rights of freedoms enshrined in the European Convention, the author proposed a periodization of the formation and development of the evolutionary interpretation of the European Convention and characterized the uniqueness of each main period at stage. An analysis of the practice of the court has developed on the basis of the application of the evolutionary interpretation allows us to distinguish between different periods and stages. In the first period was marked by the formation of the doctrine of the living instrument developed by the European Commission on Human Rights and the European Court in the late 1970s. The European Commission on the Human Rights was the initiative of the transition to a new way of interpretation. Its members were first formulated this position in their reports in connection with the study of the factual circumstances of a number of cases. The peak of the evolutionary approach to interpretation of the European Convention falls on the second period, which is associated with the creation in 1998 of a single permanent European Court of Human Rights. The court has significantly expanded the scope of protection of civil and political rights provided by the Convention, which was a direct result of the court's ability to interpret the original text of the Convention in the light of today's conditions, taking into account for transformation in society. The second chapter, theoretical and legal aspects of the evolutionary interpretation of the European Convention on the Protection of Human Rights and Fundamental Freedoms, also consists of 2 paragraphs. The first paragraph examines the relationship between the interpretation of the Vienna Convention on the law of treaties of 1996 and the evolutionary approach to the interpretation of the European Convention. The texts of the Vienna Convention and the European Convention do not explicitly refer to the fact that the courts have the power to evolutionarily interpret the norms of international treaty. Despite this, it can be argued that the studied method of interpretation of the provisions of the European Convention received an international legal basis in the requirements of the preamble of the European Convention and the need to interpret the provisions of the Convention in the light of the object and purpose of the treaty. In addition, the judges of the court attach particular importance to Article 31 of the Vienna Convention for the activities in the evolutionary interpretation of the norms of the European Convention. In addition, the abstractness of the legal language of the European Convention makes it possible to interpret Convention terms and expressions in such a way as to adapt their contents over time to ever-changing living conditions of modern Europe. Paragraph 2 discusses the European consensus method, which is used by the judges of the court to justify a new approach to the interpretation of the European Convention as a living instrument. Since the 1970s the court has been practicing references to European consensus in decisions adopted through an evolutionary interpretation of the Convention. The European Court of Justice independently determines which objective grounds to greater or lesser extent indicate the achievement of the absence of consensus. The European consensus is the main decision-making method for the court, which is related to the doctrine of the living instrument and the doctrine of the discretion of states. The presence of or absence of European consensus as a rule is crucial for the non-application of the evolutionary interpretation of the European Court. In most cases in which the court concludes that consent has been reached, there is a change in its legal procedures. Due to the lack of clear quantitative criteria for determining consensus, the procedure for applying the evolutionary interpretation of the court remains not fully understood, which creates the need to improve the methodology of analysis and assessment of the presence or absence of consensus. The problem of measuring consensus has not been resolved, since the concept of European consensus in the understanding of the court does not imply a decision-making process on the basis of general agreement between all party states to the European Convention, between the vast majority of European states. The inconsistency of the use of the European consensus is known too. In rare cases, the absence of a European consensus among the participating states is not an obstacle to an evolutionary approach to the interpretation of the position of the consensus. That's Lao Tzu versus Italy, a case on Christian symbolism in public places, including in schools. Well, this will, despite the existing methodological flaws, many lawyers recognize the importance of these methods. The third chapter discusses current issues of the practical implementation of the evolutionary approach to interpretation. The chapter consists of two sections. The first paragraph is devoted to the analysis of the influence of evolutionary interpretation on the development of the European Court of Human Rights legal practice. In general, the position of the court regarding the application of the doctrine of the living instrument is quite flexible. On the one hand, the court is very cautious in using the evolutionary interpretation and rarely radically changes its position to the completely opposite. On the other hand, the adoption of the court of new legal positions reflecting the changes that have occurred in European society since the adoption of the Convention should be assessed in a hidden form, as a hidden form of rulemaking. The judges of the court are not entities legally authorized to create new conventions, recognized as invalid, but they recognize as invalid certain provisions or otherwise make appropriate amendments and changes to the original text of the European Convention. New rights are derived from other rights contained in the Convention. In later practice, the court bypasses the previously established limits of evolutionary interpretation and is ready to modernize its convention. Unfortunately, the court could not avoid regressive decisions, and based on the use of the doctrine of the living instrument in the practice of the court, there is not only an improvement in the stance of protecting human rights reflected in the convention, but also a decrease in the effectiveness of judicial protection of human convention rights, which contradicts the object and all goals proclaimed in the preamble of this contract. The ECR used the above-mentioned regulatory grounds to strengthen its authority to interpret convention provisions, which has become an important trend in this. However, it should be emphasized that quasi-norm setting activity is an integral part of the court's methodological approach to the evolutionary interpretation of the convention. The court did not intend to limit the interpretation in the light of today's conditions to the intentions of the developers of the convention. The transition of the European Court to an evolutionary interpretation from the very beginning assumed the feeling of new content of many provisions of this international treaty. The need for judicial activism inevitably arises when the court decides to overcome the contradictions between the changing living conditions of European society and the text of the convention, which requires a complex and lengthy procedure to amend. At present, it's become increasingly difficult to deny the positive impact that the modern reading of the provisions of the convention has on improving the legislation of the states parties. The content of the convention was extended to new areas. It significantly reduced the number of individuals or groups of people whose rights are limited in the participating states. On the other hand, the negative consequence of judicial activity of the European Court manifested in the abuse of powers by judges are reasonably criticized in the works of both Russian and foreign researchers, and also cause a sharp negative reaction from the state parties of the convention. Thus, the European Court is a law enforcement body that has the right not only to interpret the applicable provisions, therefore the evolutionary interpretation of the convention should not be equal to legislative activity. The creation of a new legal position by the court does not lead to the revision and updating of the generally recognized text of the convention. Dear members of the dissertation, the report is completed. Thank you very much for your attention. Do you have any questions, dear colleagues? Mark Lolish, please, your question. The presenter, very good presentation, where you put accents that characterize your own research, but you said in your presentation that as a result of using the methodology which you described in such detail, the European Court decreases its effectiveness in the protection, the protective power of the convention. Give us some examples. Hessen against the UK, in which the court expanded the list of ways of putting people in custody. In another case, the evolutionary interpretation led to a repressive verdict, and as a result of the Hassan verdict. But there's another case in which when the bail value was so great that that was not incommensurable with that, and therefore a very high standard of the protection of the personal rights had to be involved. I have two questions. The first one concerns statement number 3 in your dissertation, in which you say that you can differentiate the development, the origin, and you can and you put the development, the history of this into 2 stages and 2 periods, and you say that that it is important that not only that the fact that the court uses this instrument, but that the number of cases where it's been done has increased. But in percentage with time, you say in the same dissertation, the number of applications of this instrument has decreased. So how can you use these mathematical calculations in this case? And can you say that before the Commission, the European Commission used it, and now the court used it? Can you deem this transition a foundation for the development of this principle of living instrument? So the percentages show that the court, as a result of the reform of its mechanism and inclusion of new countries that joined the convention, the court has become the victim of its own success. Before, the number of verdicts were less numerous before 1998, and then the court became so popular that it started to issue more verdicts and using the living instrument methodology as well. And also we can note that the improvement of legislation in the countries in terms of the evolutionary way of interpretation, and also the amelioration of the practice of the court. And so new rights were created, so to speak, in the convention, and new extracorporal conception has entered the scene, and other new phenomena. So therefore, new rights were created. But the main thing is that the pressure on the court has increased. They started to work more. Well, in Hassan versus the UK, do you understand correctly that you say that the regressive interpretation can be considered an evolutionary interpretation? Pinto versus Pinto de Albuquerque, the judge said that evolutionary interpretation can lead to such regressive decisions. Then Frosel Tzulke also said at the conference that the verdict, the Mongolis versus Spain, is an example of the evolutionary interpretation, which limited the convention standard. Yes, that can happen. Yes, Svyatoslav Igorevich, your question. I would like to thank you very much for your wonderful work, which I enjoyed reading. My question is the borderline between evolutionary and other ways of interpretation. You said in practice using the can you well, you say something that can make us believe that it's a teleological interpretation. I would like to answer your question. This is your question, which will be answered in my answer session that would address your questions from the reviews. And in terms of the methodological approaches, in terms of European consensus, what are the methodological interpretations have you done? The main problem in this area, that's qualitative and quantitative criteria of the European consensus, has not been resolved, and so therefore is not clear what is the percentage of countries in a particular area that we need to deem that there is a consensus in this area, a European consensus in this, and what sources of this consensus, for example, international treaties of these countries, or because the court has started to refer to the practice of countries that are not part of party to the convention, and so there are no strict criteria that would make us believe that there's a European consensus in this on this issue, and so therefore there should be a clarity between the doctrine of the freedom of freedom and consensus. Although the analysis of the practice, for example, by studying after studying the national legislations, etc., the court nevertheless decides that the European consensus can be ignored in this case, and I can mention some cases of this which happened, and this is another area where there's no clarity. Now I would like to ask the dissertation council members to read their views. No external reviews have been submitted, and therefore I would like to start with Vladislav Tolstych, who is in remote mode on Skype with us, and of course I would like to again draw your attention to the time limit. Vladislav Leonidovich, unfortunately there's no sound. Yes, please speak louder. Is it better now? Better. Well, the sound is not good enough. I will try to use my external microphone. So I'm going to use my external. Dear colleagues, I endorse the overwhelming opinion and commending the dissertation. This is not only commendable not only in terms of the study of the European Court of Human Rights, but broadly European legislation and legal practice. Well, I would like to add a lot of cases, legal cases have been used. It's a plus. and the author has succeeded to describe the evolution of this legal practice and how this practice influences the material law, and new in gender, new rights have been developed, and this is done very well, but unfortunately all these very interesting conclusions did not find their way into the introduction or the statements to be defended. But in terms of criticism, there's a lot of tautology, there's a lot of unclear formulations and definitions. The author calls its work theoretical and practical aspects of the evolutionary in the practice, those practical aspects in the practice of the court. And so this is a case of tautology. So one of the fifth conclusion is hard to understand as the goal setting stupefies its constitutes its direction, etc., and it's very unclear. The legal practice of is a summation of the decisions of the court, and which means that the legal practice is the legal practice. So legal practice, the empirical part is excellent, but the theoretical part is weak, and there are so many drawbacks here in terms of the conceptual drawbacks. The theoretical base is a bit weak. The whole idea of the evolutionary interpretation dates back to the beginning of the 20th century, starting with Ehrlich, and he mentioned two authors of this, the Austrian Ehrlich, and there's another author, Zeitlin, also, who wrote at the same time. But colleagues, this is not true. If we look at the genesis of international law, in the 17th century we can find authors who wrote about evolutionary, like in Suarez' interpretation. He said is the natural law is flexible. It adapts to the changing conditions, and but the author makes creates an impression that the international law was created in the 20th century, which is not true. The author doesn't try to find out what interpretation is. As a metaphor, it's a castle built on sand, shaky ground, and interpretation is a key term, and because we cannot not include Foucault or Einstein or whatever, and other linguists, for example, and Romanian Bedimisti's works are not used, and even the British authors are not included. And there's the result that leads to the third group of drawbacks is the weakness of conclusions. The argumentation is not valid in many cases. You already heard that the evolutionary interpretation is not is not a part of the teleological interpretation. He's trying to prove that it's part of an institutional phenomena, intentional interpretation. Sorry, in an institution, and but we have Costa Rica against Nicaragua, where the international court said that evolutionary interpretation is an intentional interpretation when states entered into an agreement. They intended that these the provisions of the agreement could be flexibly interpreted and according to their intentions. I would like to say that the author doesn't define the nature of European Court's decisions, that their de facto rule making. This doesn't add much to the understanding of the role and work of the European Court of Justice, and as a result, I think these are drawbacks of this work, but it's also a part of a bad trend in the Russian legal practice, in which the national legislation in the area of protection of human rights drifts away from the European international law, and there's a fragmentation of international law in this area. So, but there are good parts and the good empirical studies, and this outbalances my negative parts, and therefore I conclude that the dissertation complies with the requirements for the degree. Thank you very much. Dear colleagues, I would like to start with commendation, and it was an enjoyable read. I would like to congratulate the author on this work, and in both Russian and English, and this work can be a good beginning for a monograph. But of course, if corrections are made and if the author addresses in a healthy way these criticisms, I would like say that evolutionary interpretation is very relevant as a method. It's doomed for controversial, to be controversial, because the doctrinal framework of this discussion can be ongoing forever. And whatever approach you use to evolutionary interpretation, it will be prone to criticism. Well, you take the European consensus, for example, they used to prove the validity of the evolutionary interpretation. The court will has the right to demand of states only those things that the states are already doing, what is are already doing, and anything that goes beyond that will be considered as a leveling off or denigrating the contribution of the states party to the convention. And so any legal practice of any court is prone to criticism, and so this attempt of Svyatoslav Igorevich to understand the complexity of the situation deserves commendation. And the author has analyzed a huge number of legal decisions and doctrinal sources and reports, and of course it contributed to the high quality of the work. And I would like to also add here, as the work is has a very argumentative character, and the author tried to steer between the poles of the controversy, and this is a good thing, and this is an academic kind of way, and this way, and therefore we can say that the author of this dissertation has a future as an international lawyer, a scholar of the international law. And as far as the criticisms, they are different. I have some concrete, some more abstract. The first one has to do with methodology, and I would like to say that when reading your dissertation from first to last page, I could see that you would be using statistics and statistical analysis, etc. I was very happy to see that because unfortunately this approach is not is underused in our national scholarship, and I was enthusiastic about that, but when I analyzed your text, unfortunately my expectations were betrayed a little bit because you used the statistical approach in a way that I don't approve really. How do you, in terms of use, you could use Hudok approach, and you could use all the definitions that that they provided, but you could not limit yourself to it, because well, for example, this you used a simple search of the keywords evolutionary interpretation in all the decisions, but you can say, unfortunately, this approach was used in some cases and explicitly was not mentioned in the decision, or on the other hand, it was mentioned in the decision, but in fact it was not really used in the decision. And so, as far as the analysis of the data, when you use this linear approach, you are losing out a lot. So you mentioned that you make a conclusion that where these words evolutionary interpretation were used, they to you they are pioneer cases or original cases. Unfortunately, they're not in many cases such. And the second commentary has to do with the key issue as your approach to evolutionary interpretation, as your conclusion is that evolutionary interpretation is a separate way of legal interpretation. In the doctrine, I think that evolutionary interpretation can be presented as a combination of known ways of interpretation, both from common law and evolutionary interpretation as a result of interpretations, and the effectiveness, judging on the effectiveness of decisions. And in your dissertation, I didn't find an answer to my questions that I had, or where you could disprove that this is actually a result of different interpretations. And you say that in some parts you say that the doctrine actually states that evolutionary interpretation is rooted in this and that body of legal practice, but on the other, in another part, you say that's the absolutely pioneer original interpretation, and so there are other contradictions as well in your own positions. The third, Hassan and versus the United Kingdom. This is I beg to disagree with you strongly here. That this is the extreme form of evolutionary interpretation. That it actually evolutionarizes the text of the convention. But I would like to draw your attention to this. The court refers to the block of norms of international humanitarian law, where you have a status of interns in combat, and but also and other stipulations. The court made a decision that the list could be expanded, and the putting someone into custody based on the protection of rights could be interpreted as part of the existing list of rights. You in another place you mentioned that there's an evolutionary interpretation that that shows that we have a disagreement of how we interpret evolutionary interpretation. I would say that it's a result of the interpretation. You say that it's actually the method, and I would say that by using your own methodology, Hassan versus the United Kingdom actually cannot be considered a case of the application of the evolutionary interpretation. In many cases where evolutionary interpretation is used, the European consensus is used. But to my mind, it's more important, it's not, and instead of analyzing what kind of percentage of judges or states were included in assessing whether there is a consensus or not consensus, well, you should have probably looked behind the courtroom and try to analyze what made the judges take a particular stance, whether or qualitative, whether these changes, whether these changes of opinion were personal opinions of the judges, or they followed the trends in societies they come from, or European society in general, or the changes in the legislation of the countries, European countries that are involved, and this would have been more valuable. And European consensus is not well, maybe we could see the use of, in a particular decision, the use of evolutionary implementation was under the pretext of the European consensus, and whether the European consensus was used as a smokescreen, and this is not. And because you didn't do that, your dissertation, of course, lacks some substance in terms of the political perspective. You didn't pay much attention to the relationship between subsidiarity and evolutionary interpretation. There's a we cannot, as international legal scholars, cannot ignore political changes, and I couldn't find any reference to the Brighton Declaration or Brussels Declaration in which states step by step try to focus on subsidiarity, and they criticize this way the application of evolutionary interpretation in so many cases, and as a counterbalance, this movement, or even peddling of the principle of subsidiarity is used and promoted. And the last comments were general nature, and this is well, you'll decide whether this comment is valuable, because in Russian legal practice we still operate within the positive law perspective. I think that evolutionary interpretation is was a very good way, would have been a very good way to go beyond the positive perspective, law perspective, and in three ways could be. you could look at it from a realist school of international law, constitutionalism, or indeed critical critical studies of theory of law. And so you could open up new depths in this area. And there's, as a conclusion, I believe that the result that we see is a serious contribution and a starting point, and on the basis of this dissertation, a good publication can come out, and the author should pursue the study of the human rights law. Thank you very much, because we need young researchers there, young scholars there. Mark Kovalenko, please. Dear Chairwoman, dear colleagues, I would like to take up the baton, and this is not a detective story. I would say outright that I like the work. It's a professional study. The conclusions are substantiated with the content of the research, and the publications, the key issues are addressed in the publications that are mentioned in the dissertation. Now, in GIMO, we don't mention any positive sides of research work, but the protocol here allows me to do that, and so this work is one of bravery, and I thought the author was a big guy with a beard, because the topic and the study is something that invites a lot of debate, and so many opinions exist on the matter, and this is not strange, because the practice of the European Court of Justice on human rights and other courts needs to be studied, because it has a lot of they hold a lot of risks for international law. The precedent material has been well researched, and the European Commission and several stages or periods are studied of the evolutionary interpretation, implementation, and in which the need for a doctrine was highlighted and described, and so the evolutionary interpretation, of course, followed the changes in European society. When I talk about the the critical moments, it's not that I'm talking about drawbacks. I'm talking about some under-researched maybe areas. Russian schools of comparative legal studies are reviewed. Well, of course, you could have used the MGIMO school. We have some journals there where we have published our recent results and where we analyze how the assessments, the values of the 90s and today correlate, and we also publish our research in Italian, Indian, other journals. I would like to go over very quickly my comments because there's a time limit. When there's a stance that the court should not refuse deny the right of protection. Well, this stipulation as a function of the function of the court has existed forever, and the court follows this procedure is where the national courts didn't resolve this situation, and so the person applied to the European Court of Human Rights. It should act. This is of principal importance because what existed before the Court on Human Rights, the European Court, has not invented this principle, but no other court has applied this principle so aggressively, so consistently, and so we should see from this perspective we should look at the problem of human rights court activism, and this issue has not been resolved yet in legal science. The legal instances that there were bodies that only interpret and apply the law, whether they actually have the right to create law. Society. Well, there should be a very determined character of law, because society, economy, etc., can only function in conditions of the determinacy of law, and the internet and other new phenomena, they can, if they are to work there should be at the same time flexibility. If a court system starts to forget that there should be this balance between the rigidity and the determinacy of the legal system and its flexibility, then there are negative consequences. And history shows us, and some states differ in values too. Another thing I would like to underscore, that there should be a very close look at the recent practice. What is the principal difference between the two branches of law? Human rights and the result law, valid of the result, and whatever institutions are used, there should be a result. Either the result is the deepening of integration, or the result is the protection of the rights of an individual. And in order to protect this individual's right, you have to use evolutionary interpretation. But if your gun sight is broken, but if we, instead of interpreting, you go into the battleground of political struggle over values, then the situation changes. We have a deadlock with the application of the concept of effective sovereignty over an alien territory, or influence over it. There hasn't been a situation that this approach could lead to the protection of human rights of people. With the Transnistria Republic, for example, everybody, the human rights, for example, the use of languages in schools, different schools. For example, Russia, which was accused of violating this right, was actually removed from the decision-making process, and there's a gap between political reality and the legal reality, and this has to do with the European Court on Human Rights. So there's a problem that there's a discrepancy between the decisions and the oversight bodies that control the compliance of the national authorities with the decisions of the Human Rights Court, and we have to look at the situation at different levels of governance, local and municipal or national, whatever. And that's, well, how maybe we could look at this evolutionary development, and there are other cases that way we could apply the same mechanism, and there are also there are also issues that are discussed in the dissertation but need to be discussed further. There are some controversial cases that decrease the protection, or some kind of undetermined results. But in principle, but the doctrine considers the application of the living instrument leads to progress. But what is progress? For example, this evolutionary approaches destroys the traditional family, or classical beliefs of concepts of religious beliefs. There's different areas with the progressive movement, and there are many issues here that have to do with personal safety, security. Maybe the states should return to the classical division of powers, the legal, the executive, and the judicial branches of government. Maybe the problems, the so many problems, the court and the Council of Ministers of Europe are facing. They're facing because the states they stopped codification of their their legal system in terms of progress. So this leads to the situation where the court can actually be overloaded. And for example, in Hungary or in Britain, show that we have to deal with this problem in a more detailed manner. Well, the chair man is looking at me in a very insistent way because we have a time limit. But I would like to wish the author of the dissertation to continue this research, because at the level of candidate degree dissertation you can open up some areas, but at a doctoral, senior doctoral level, you can look at these areas in depth. And so I'd like to conclude that what I like about this dissertation, when you don't agree with what you read in it, you have new ideas, you see new perspectives, and for research, this is the main thing. So the conclusion was at the beginning, I evaluate the work highly, and it deserves the degree, the third degree. And then Dmitry Kochinov, your word. Before I congratulate you on, I am very sorry that I will speak in Russian, and I haven't worked in Russian for 20 years now, although in the Russian university that I studied law was taught in French, so I saw a lot of new things. I think that your dissertation is well written. It meets the goals that you set before you, and I will explain why what I disagree with. As a starting point for me, this is a dissertation that deserves a degree. What I was impressed with in the dissertation, because this is very neutral, absolutely neutral. There are many works, studies that you see in leading journals which support 100% a certain trend or methodology that courts use, and all the painful points of using new approaches are analyzed in a neutral way, objective way. This is one of the best starting points. So the relevance is there, and side by side with neutrality, and the good detail. And you study a lot of precedents and the reference to conventions, etc. This dissertation is very valid in terms of the presuppositions. Well, this dissertation is not pretentious, but on the other hand, it's still lacking in clarity. Could you clarify what type of research work would you attribute to dissertation to? What would so the goals of the dissertation, well, and of course the book as a genre works with periodization and so on, but this genre doesn't really do that. Well, I would love to see what are the alternative ways of treating the phenomenon under study. In your dissertation, you describe the development of a method of interpretation, but you don't explain why this development has taken this path and not another path. The periods are great, but this is not theory that would explain the reasons. Well, you work with lots of sources. What you ignore among their sources are the sources that study the jurisprudence of courts in a different way, and they explain not only chunk the development. There are 2 or 3 theories that could help you to clarify what you what you describe is happening. there are some global research. There's some global research that includes international law, textual analysis, international law. That would help. Using these studies would help you to explain what you're describing. Summing up, I would say that if your science is not the science of explanation, and legal science is not always that one of explanation, then I respect your work, and I would agree with Professor Antin. This is just the beginning of your academic career. So on the basis of your work, you can delve into different research areas, and could be a series of research publications, articles, and that would constitute valuable contributions to the body of literature that we have now in this field. And I would urge you to do that. And thank you very much. Thank you very much for your review. And then I would like to read my review. Stanislav Igorevich presented a thesis that I enjoyed reading, and I agree with the positive comments and the critical comments. I will start with some considerations that are not maybe criticisms, but some observations that I had when I read your work. These considerations shouldn't be interpreted as criticisms, but rather as considerations. The quality of the research dissertation, the quality of the research prompts some of these considerations. The first one has to do with methodological apparatus. This is a formal state consideration, and I will probably omit mentioning it. We all agree that there's so much ahead of Svyatoslav in terms of research, and most of it is ahead of. And what has been mentioned already, the methodological reproach on empirical analysis, I had the same concern. The second one is has to do with the concept of evolutionary interpretation. I agree here with Vera Nikolaevna. I have a series of questions. I will just mention some of the more painful ones. I would like to disagree that evolutionary interpretation is a method of interpretation. When we say that, is that this method of interpretation it coexists with other methods of methods like interpretation, like teleological and others that exist in the doctrine. You juxtapose evolutionary interpretation and static interpretation as a dynamic interpretation. And judging from this, evolutionary interpretation is not a way, but a tragedy of interpretation. The ideology of interpretation, but not a way of interpreting. Evolutionary interpretation is an example of the fact that the doctrine since the early 20th century, what Carl Levelins referred to grand style, Ralph Ross, free style of court interpretation, or the nightmare of legal realism. Well, there are different terms, but of the approach that we call evolutionary interpretation when we talk about the European Court on Human Rights, protection of human rights. And I provide arguments in my review, and I will just make some points here. The court, by implementing evolutionary interpretation, uses creative interpretation. It changes the object of interpretation. This is a known attribute of realistic approach to interpretation. And Stanislav mentioned interpretation contra legem, which contradicts the text of the convention. The true meaning. Well, but unfortunately, you're right. That this doctrine is designed to change the convention. This is again has to do with the realistic approach. Well, these characteristics that you mention when you describe this evolutionary approach, the court sets the meaning, which is a characteristic of realistic interpretation. Another thing, there's a lack of clarity of relationship, this type of interpretation and teleological interpretation. There must be a mistake in your work because your reasoning is based on the existence of contradiction between the goals, the objective goals of the agreement, and the goals of the intentional goals of the founders of this agreement, and this is unfortunately uncritical point, and this is used by you to reject the teleological perspective, the convention is an outdated document, according to you. As you answered this question in your opening statement, but there are some issues, and I agree with the concerns that you've heard already from Mark Lvovich, and the question is here: what are the criteria that allow us to identify some provisions of the convention as outdated? The second thing is this adaptation. Are there any limits to meet the changing environment, legal environment, social environment? Well, new rights, for example, implied rights, can put under question what nature of man, new nature of man, they actually reflect. When you look at the normativity of the acts of the court, you mix up legal precedents or court precedents and legal norm setting. There are 6 arguments in my statement, in my review, that show that the normativity of legal precedents and judicial precedents and norm setting, these two phenomena are entangled in your work, and also you try to present all the controversial positions on the issue, and unfortunately there's a risk that you run here, that you may be trapped here, is that with all these conflicting opinions, you never know what opinion the author of the dissertation adheres to, but on the whole, I agree with my colleagues that the dissertation complies with the requirements of St. Petersburg University on the conferral of the Candidate of Science degree, and Svyatoslav Igorevich is entitled to this degree. Svyatoslav Igorevich has 15 minutes to answer the questions. Dear Chairman of the Dissertation Council, I thank you for the critical comments, and these are the highlights for me to look at when I do my further research. First, I will turn to questions about the evolutionary interpretation in the practice of international court of justice, the United Nations, and other international courts. I agree with the excursion to a history of evolutionary interpretation could be expanded, in particular by setting forth the extremely important position of the International Court of Justice of the United Nations. But I was decided to focus directly on the practice of evolutionary interpretation and the provisions of the Convention by the European Court on Human Rights, and because it has its specificity, and the next level or the next stage of this research. But the UN International Court of Justice is not completely disregarded. It's taken into account in the dissertation. For example, for that court, the UN court, the first stage of the justification of the evolutionary interpretation, which implies the establishment of the initial intention of the parties reflected in terms of the treaties, is more important than for the European Court. It is in its evolutionary interpretation, the European Court of Justice proceeds from the understanding of the Convention as a living instrument, and therefore pays less attention to the initial intentions of the parties when creating this international treaty. Even if the judges of the European Court on Human Rights turn to the preparatory materials during the implementation of the evolutionary interpretation, they can draw a conclusion that it is opposite to the evidence contained in them. And thus, in a ruling in the case of Young, James and West versus the United Kingdom, considering the issue of mandatory mentoring of trade union, the court turned to preparatory materials and recognized the existence of a negative aspect of the human right to freedom of assembly and association, not to be a member of trade union, which was not deliberately included in by the contracting parties in the text of the European Convention. This feature indicates that the living tool approach, or the living instrument, has only a weak connection with the parties' initial intention. The foregoing does not mean that that an evolutionary interpretation leads to a complete rejection of the intentions of its drafters. Therefore, I will turn to the question of the intentionality of the evolutionary interpretation and this connection with the intention of the contracting party of the Convention. The work indicates that in implementing an evolutionary interpretation departs from the subjective intentions. For example, Justice Sicilianos emphasized that the drafters of the Convention did not perceive human rights as a static fact. The ambiguity of the legal language of the Convention, the lack of detailing of each right, is evidence that the participating states realized that the generalized concepts formulated in the Convention make it possible to adapt the Conventions to a constantly changing public environment. And therefore, it talks to the longevity of the Convention and also allows the judges to adapt its norms to social, political, and other transformations. As far as the periodization, on page 57, I point out that the key phrases analyzed are found in the motivation part and in the dissenting opinions of almost 190 judgments of the court for the period since 1978 and not since 1998. Of these, 170 are for the period of between 1998 and 2018. Then there are 20 years. There are 20 years of the second period and 20 cases with an evolutionary component for 20 years in the first period. That is 8.5 times more than which is indicated in 59 pages. And in the 121 ruling that I mentioned on page 27, it's not the total number of rulings issued between 1998 and 2010, but the number of rulings that use the very expression comparing the Convention with a living instrument in English and French, living instrument, instrument vivant. In other cases, the text of the decision of this expression do not. The chronological frames of the sample outlined, and this is not only the period between 97 and 2018. This refers to the period from 1917. For example, in the case of Tyre and versus the United Kingdom, this sample includes this example includes not only a decrease in which convolutional interpretation is applied, but also in which the idea of the convention is a living instrument was somehow reflected. And therefore, the results obtained are based on the analysis of cases that have an evolutionary component. That is, indicate that in the practice of the international judicial body, the idea of an importance of protecting the rights set forth in the convention through an evolutionary rather than a static interpretation has become widespread. So, the words of the European Court judge from Slovenia, Šupančić, are quoted that only some of the cases in which the phrase living instrument is found are really new and interesting. This especially applies to the second period, which accounts for 90% of such cases. But this, and so of course, I agree with the error that the statistical error is that I may have made, because I base only on the explicit mention of these words, rather than on reading through the decisions. I will answer the number of questions and comments. Thank you very much. Please, I would like you to be more brief. In my work, I try to consider European consensus as a controversial phenomenon, but I point out that the European consensus is seen as the most important barrier against arbitrary interpretation by the Court of the Convention, even as a self-restraint aspect imposed on itself by the European mechanism imposed on itself by the European Court in interpreting the Convention. But the European consensus contributes to the as a transparent mechanism for substantiating conclusions when the Court applies the European consensus in practice. The European consensus is the most effective way of legitimization by the Court of its rulings. And answer to Vera Rusinova, the European consensus underscores the subsidiarity of the Court. And the Court should or must actually take account of the Court decisions in different countries from where where the case was tried. So the European consensus allows integrating decisions that are taken at the national level into the practice of the Court. In this context, it is considered as a collective decision that provides the Court with the opportunity to demand from states that deviate from the general position of the implementation their decisions if they're adopted by a majority of the contracting parties, if they have no good reason. So the legitimacy is a very important issue here. If the Court demonstrates the openness to dialogue with the national jurisdictions, the European consensus actually is an instrument to show that it does. I would like to say now why evolutionary interpretation actually has been adopted by the Court. There's no consensus on how to in the literature of how to approach the evolutionary interpretation, whether it's a method of interpretation or norm making. There are different approaches. Most tribunals haven't agreed with the evolutionary interpretation as a separate method of interpretation. But the court insisted on it, that it is a special, that about the doctrine, the interpretation which was developed because of the necessity to interpret the convention text, and this interpretation, it actually interprets. Well, you're retelling your own work, so please just focus on the question, and please conclude your answers. This is the criteria. The European Convention has a specific character, special relationship with between teleological it treats the convention in a new way compared to teleological interpretation, and I would cite Lizevsky here. This interpretation was only a starting point, and this will be my concluding statement. Thank you very much. Thank you very much, Svyatoslav Igorevich. Any questions? Then I would like to give the floor to the academic advisor of the dissertation, or the author of the dissertation, just in defense of the concept. We do research, and we also teach. We supervise research, doctoral research. Some started well but didn't complete, and some started in a very slowly and completed a good work. This is the second case. Some researchers, young researchers, take up a very fashionable topic and pursue the research in it, about the WTO, but the fashions fade, the foam subsides, and then, but this young man comes up to me and says that the evolutionary interpretation of the legal practice of the court case. Well, this is a topic to be tackled at the doctoral level, really. Are you sure you're going to take it? Well, will you? Well, I want to tackle it, and over 3 years it has researched, and we will look at the sources cited, the sheer volume of literature, and we're just amazed. On the one hand, this is a large topic, but in our we see that there's fragmentation of law. There are no jurists that know the entire body of international law, and this is inevitable that scholars of international law specialize, some in WTO and some in the European Union law, some in the European Court on Human Rights, and this specialization is a negative trend maybe, but it's actually a prerequisite for scholarly success. But unfortunately, it's this process is not to be avoided. And to conclude my eulogy, very persistent guy. We meet with him. I say, this is not true. I'm your supervisor. I don't agree with it. Well, this is my opinion, he answers. I believe in it. And of course, there are some, as you mentioned, there are some discrepancies there. But he said, well, I disagree with you. This is my point of view, and I'm going to retain it. Well, I think that this is good. I think this testifies to the complete independence of the researcher. And I would not sing an ode to this person, but of course he's a very stubborn young man. But what we have, we have. But this is also a very good trait as well. Well, he is a very subtle looking young man, but this is a deceiving, misleading appearance, and he is a very, very firm person, and I endorse the positive resolution to grant the sword degree. Well, do we have any questions for Svyatoslav Igorevich? No questions. And then we're going to switch off the broadcast. And we're going to discuss, deliberate the verdict, the resolution of granting or non-granting. Please, members of the audience, including the author of the dissertation, over. Dear colleagues, our session is continuing. I would like the broadcast to be switched on again, and I put to the vote the resolution on conferral on the degree of candidate of sciences on the author of the dissertation, and the resolution to confer the degree is valid if not fewer than 3 members of the dissertation council vote for it. And please, Vladislav Leonidovich, your opinion. I believe that the author of the dissertation deserves the candidate of sciences degree. I vote for this. I vote for the resolution. I vote for the resolution. I vote for the resolution. So there are no alternative positions, and by unanimous vote, the dissertation council confers the degree of candidate of legal sciences on Svyatoslav Igorevich. And so, Svyatoslav Igorevich, you have the right to make the final statement, as it is called. Thank you very much. I'll be very short. I would like to thank Alexei Stanislavovich to take me under his supervision, and that he tolerated my obstinacy. And I would like to thank my mom for supporting me all the 4 years that I've been writing this dissertation. I would like to thank the Faculty of Law of Moscow State University, and the members of the dissertation council for the comments. Larissa Viktorovna, for your help in submitting the documents to the dissertation council. Thank you very much. Congratulations to Svyatoslav Igorevich with this verdict of the dissertation council, and I thank all my colleagues for participating in this dissertation council meeting, and I close the proceedings. Thank you.
Я благодарю, конечно, Владислава Леонидовича, удаленно участвующего. Спасибо вам большое. Ну, видимо, до следующих встреч.
Спасибо. До свидания.
Спасибо, до свидания.